Hello friends, welcome back. Today we are reading P.A. Inamdar versus the State of Maharashtra. Citation for the case is 2004-8 Supreme Court Cases 139. The matter was listed before the court of Honorable Justice RUMA Pal and Arun Kumar Justices. The matter pertains A. to the Constitution of India under Articles 19(1)(g) and 19(6), Article 31, Article 26A, and Article 15(4). The right to establish and administer educational institutions, autonomy of private unaided minority and non-minority professional colleges, petitions raising issues relating to fixation of admission quotas and the holding of entrance examinations, all issues which related to interpretation of T.M.A. Pi case 2002-8 SCC 481 and Islamic Academy case 2003-6 SCC 697 matters refer to a larger bench. Interim orders given for the academic year 2004-2005 in respect of the fixation of admission quotas and entrance examinations. B. Constitution of India Articles 19(1)(g) and 19(6), Article 31, Article 26A, and Article 15(4). Words their needs occurring in Islamic Academy case 2003 6 SCC 697, page number 730, paragraph 19, refer to paragraph 6 herein, held refer to the needs of the minority or non-minority unaided professional colleges and not the needs of the state. C. Constitution of India, Articles 19(1)(g) and 19(6), Article 31, 26A and 15(4). Exception to the rule in Islamic Academy case 2003-6 SCC 697 at page 728 paragraph 16 see paragraph number 11 herein, granted in respect of those institutions which had their own admission procedure for the last 25 years, questions whether A. the restriction of 25 years would apply in all cases irrespective of the merits of the institutions or their background, or whether such a restriction was contrary to the decision in T.M.A. Pi case 2002-8 SCC 481. B. The decision in Islamic Academy in paragraph 16 which limited the right of a minority unaided professional institution to hold an entrance examination on its own was in the teeth of the pronouncement of the 11-judge bench decision in T.M.A. Pi in respect of the right of the minority to evolve its own procedure and method for admission. C. The clarification of certain phrases such as for example and particular type occurring in the said para 16 of Islamic Academy case, and D. Whether the decision in Islamic Academy did not cover a situation when there is only one professional institution belonging to the minority, in which case it would not be in a position to form an association at all left open. Order. IA number 28. Issue notice returnable within 1 week. Thus the service is permitted. The petitioner seeks to fill the vacant seats which remained vacant after the state has admitted the candidates who had succeeded in the common entrance test with outside candidates who were successful in the examination held by the association. State of Karnataka in IA number 31 and 33, writ petition number 276 and SLP civil number 11244 of 2004. All these three cases relate to the interpretation put by a bench of 5 honorable judges in Islamic Academy of Education versus State of Karnataka on the 11-judge bench decision in T.M.A. Pi Foundation versus State of Karnataka. In all these cases, the immediate disputes relate to the fixation of quota in respect of unaided professional institutions and to the holding of examinations for admission into such colleges. We are of the view that the issues raised should be referred to a larger bench for final determination, having regard to the nature of the controversy involved in these cases. The question then arises as to the interim measures to be taken by these colleges for the academic year 2004 and 5. it is stated by the state of Karnataka that pursuant to the decision of this court in Islamic Academy, the state government had fixed the quota for unaided or private minority professional institutions at 50-50, and in respect of other private unaided professional institutions at 75-25. That is, 75% of the seats in these colleges would be filled by the state government and 25% by the management. The state government has justified the fixation of such quota relying upon paragraphs 12 and 19 of the decision in Islamic Academy case. It is submitted that as far as the unaided minority institutions are concerned, they had not complained against the fixation of quota either to the state or to the committee which has been set up in terms of the decision in Islamic Academy. The non-minority association's complaint to the committee regarding the percentage as determined by the state government has been rejected by the committee. A writ petition was filed by the association of the non-minority unaided professional institutions before the High Court, which is still pending. The matter was mentioned before the High Court at the instance of the state government that it would seek clarification of the issues from this court. It is pursuant thereto that the state government has filed IA number 33 to seek directions. As far as the quota is concerned, the Learned Counsel appearing on behalf of the unaided minority institutions has stated that for the time being and strictly without prejudice, they are willing to abide by the quota fixed by the state government. As far as the non-minority institutions are concerned, they have drawn our attention to paragraph 21 of the Islamic Academy case and have submitted that this court had permitted 50-50 quota as an interim measure. It is also stated that for the immediately preceding year, that is 2003 and 4, since the admission had already been made on the basis of 75% and 25%, pursuant to the directions issued by the state government for that year, the non-minority institutions did not protest and agreed to allow the same to continue for that academic year as a one-time measure. They, however, insist that for this academic year, they should be permitted to admit the students on the basis of 50-50 percentage and the fixation of percentage at 75-25 in favor of the state government was wrong and based upon a misreading of the Islamic Academy case. The sentence in the judgment of Islamic Academy case, which appears to have created the debate between the parties, is SCC page number 730 para 19. It is clarified that different percentage of quota for students to be admitted by the management in each minority or non-minority unaided professional colleges shall be separately fixed on the basis of their need by the respective state government, and in case of any dispute as regards the fixation of a percentage of quota, it will be open to the management to approach the committee. According to the institutions, the phrase their need refers to the need of the minority or non-minority unaided professional colleges. The state government, on the other hand, has contended that the phrase meant local needs or the needs of the state government and not that of the institutions. The issue will ultimately have to be resolved by a larger bench. We are prima facie of the view that the phrase their needs in the sentence quoted above refers to the needs of the institutions mentioned and not of the state. In the circumstances, we are of the view that the interim measure, as stated in paragraph 21 of the Islamic Academy, namely that the seats should be filled up by the institutions concerned in the ratio of 50-50, will be continued for this academic year purely as a temporary measure and without prejudice to the contentions of the parties for the purpose of final disposal. The next issue relates to the question as to who should hold the entrance examination for admission into these institutions. As far as the non-minority institutions are concerned, their association, which has been recognized by the state government, has already held an entrance examination, and there is no dispute that admissions to the members of the association will be made on the basis of such entrance examination. The dispute is with regard to the examination to be held by the minority institution in this case, that is, 14 minority professional institutions which were unaided and which formed an association. They registered themselves and applied to the committee for permission to hold examinations for admission to the seats of the institutions which were members of their association. The necessity of forming the association was by reason of the following sentences in Islamic Academy case, SCC page number 728, paragraph 16. In quotes, in our view, what is necessary is a practical approach keeping in mind the need for a merit-based selection. Paragraph 68 provides that admission by the management can be by a common entrance test held by itself or by the state university. The words common entrance test clearly indicate that each institute cannot hold a separate test. We thus hold that the management could select students of their quota either on the basis of common entrance test conducted by the state or on the basis of common entrance test to be conducted by an association of all colleges of a particular type in that state, example medical, engineering and technical, etc. The common entrance test held by the association must be for admission to all colleges of that type in the state. According to the state government, it is clear from the aforesaid paragraph that the association would have to be of all the colleges of that type in the state. It is stated that there were 38 professional minority unaided professional colleges, of which the association, which is before this court, represented only 14. The remaining colleges had agreed to abide by the merit list prepared on the basis of an entrance examination as held by the state, and in some cases had agreed to abide by the results on the basis of the examinations held by the non-minority unaided professional institutions, COMID K. It is stated that it was not open to the institutions to form a separate association and insist on holding a separate examination. In any event, it is pointed out that the prayer was not that the association should hold the entrance examination, but that the individual institutions should be permitted to do so. According to the petitioners in SLP Civil number 11244 of 2004, each institution had, prior to the decision in T.M.A. Pi, held their own examinations for admission to their institutions. As far as St. John's Medical College, Bangalore, and Islamic Academy colleges are concerned, both these institutions were mentioned in paragraph 17 of the Islamic Academy case. The claim of the institutions was, however, disputed. It is not clear whether this claim has since been resolved. As far as the colleges of Islamic Academy are concerned, however, as far as St. John Hospital is concerned, the committee permitted it to hold a separate examination for admission. As far as Islamic Academy is concerned, the dispute is still at large. The court has only made an exception to the rule quoted earlier in respect of those institutions which had their own admission procedure for the last 25 years. It is the submission of the Islamic Academy that ever since it has been established, the college in question has been holding separate entrance examinations, and that this arrangement had been permitted by a series of orders passed by this court in T.M.A. Pi case. It is stated that the observation in Islamic Academy case restricting unaided minority professional institutions from holding their own examinations unless they had done so for the last 25 years would not apply to the institutions which came into existence later. It is also submitted that there is no reason to restrict the right to hold examination to only those institutions which had been in existence for 25 years or more. We need not go into these submissions at this stage, as it would require us to go into the question whether the restriction of 25 years would apply in all cases, irrespective of the merits of the institution or its background, or whether such a restriction was contrary to the decision of T.M.A. Pi. By way of an interim measure, we permit the Islamic Academy education colleges to hold separate entrance examinations in terms of order dated 18/8/1993 as reported in Sahal H. Musaliar versus State of Kerala paragraph 17 at page 117 and 118, and as continued from time to time by order dated 4/10/1993 reported in T.M.A. Pi Foundation versus State of Karnataka, order dated 5/4/1994 reported in T.M.A. Pi Foundation versus State of Karnataka, para 7 at page numbers 740 to 741, order dated 11/8/1995 reported in T.M.A. Pi Foundation versus State of Karnataka at para 27 pages 230 to 231, and order dated 9/8/1996 reported in T.M.A. Pi Foundation versus State of Karnataka at pages 111 to 112. It is made clear that this order is limited to Islamic Academy education colleges alone. State of Maharashtra in SLP Civil number 9932 and 9935 of 2004. These special leave petitions relate to a single minority unaided professional institution in the state of Maharashtra. The issue has arisen in connection with M.A. Rangoonwala College of Dental Sciences and Research Center, Pune. It is the only minority dental college in the state. The dental college had applied for permission to hold separate examinations as far as its institutions are concerned. Before the committee set up, pursuant to the decision of the court in Islamic Academy case, the committee rejected the request on the ground that Islamic Academy case did not permit a single institution to hold separate examinations and there would have to be an association of colleges or institutions before any permission could be considered to be granted. The college then filed a writ petition before the Bombay High Court. This was rejected and hence the special leave petition. It is a submission of the Learned Counsel in support of the petition that the decision in Islamic Academy case in paragraph 16, which limits the right of a minority unaided professional institution to hold an entrance examination on its own, was in the teeth of the pronouncement of the 11-judge bench decision in T.M.A. in respect of the right of the minority to evolve its own procedure and method of admission. In support of this submission, a reference has been made to paragraph 58 as well as the answers to questions 4 and 5a of the minority view as well as the views of Khare Justice as he then was at paragraph 229, Kadri Justice at paragraph 247, Pal Justice at paragraphs 35 to 55 and Variawa and Bhan Justices at paragraph 450. To submit that all 11 judges had unanimously agreed that as far as the minority unaided professional institutions were concerned, they could evolve their own procedure. The Learned Counsel appearing on behalf of the petitioner has submitted that even assuming that there was no conflict between the decision in Islamic Academy case and T.M.A. case, nevertheless there are certain phrases which would require clarification, such as the phrase "for example," as well as the phrase particular type, etc. It is also submitted that the decision in Islamic Academy case does not cover a situation when there is only one professional institution belonging to the minority, in which case it would not be in a position to form an association at all. As we have already indicated above, we do not think that it would be appropriate for us to finally decide these issues. We are limiting ourselves to the grant of an interim order considering the urgency expressed for the academic year 2004 and 5. When the matter was moved before us as a special leave petition, we had passed an interim order on 28/5/2004 after notice to the state permitting the petitioner to hold the entrance examination, but made it clear that the admissions made on the basis of such entrance test would be purely provisional and subject to further orders of this court. Subsequent to this, an affidavit has been filed by the state government and an interim application is being finally disposed of. The Learned Counsel appearing on behalf of the state has submitted that the decision in Islamic Academy case as it stands today clearly provides for only two methods of admission to a college, namely either through the common entrance test held by the state or by the recognized association. There was no third method. It is submitted that in this case, examinations have already been held by the state as well as by the Association of Unaided Professional Medical and Educational Colleges on 22/5/2004 and 30/5/2004 respectively. Pursuant to the interim order, the dental college in question has also held separate examination on 25/2004. On the basis of the examinations as held, admissions have been made till now on the basis of the examination held by the institution itself. No admissions to the petitioner college have been made on the basis of CET or the entrance examination held by the non-minority association. As far as the state of Maharashtra is concerned, it has fixed the quota at 75-25 in respect of minority professional institutions, that is 75% in favor of the institution and the balance in favor of the state government. The institution in this case has already admitted 70% of its quota by holding its examination and is in the process of admitting the rest. Having regard to the facts of the case, we permit the petitioner to conclude the process as far as the management quota alone is concerned. This interim order will continue till the disposal of the special leave petition. SLP Civil number 9935 of 2004 relates to an association of 5 Unani minority unaided medical colleges. They have similarly held an entrance examination and admitted students pursuant to the order passed by this court. Interim relief granted in SLP Civil number 9932 is also granted in this SLP. State of Andhra Pradesh in IA number 30 of 2004 and writ petition number 350 of 1993. This application has been filed in Islamic Academy case matter. The applicant is an association of 14 professional engineering colleges, of which 12 are engineering colleges and 2 are pharmaceutical colleges. They applied for recognition before the committee set up under Islamic Academy case. The committee rejected their application, and as such they were not permitted to hold any examination for admission to the colleges which are members of their association. They have also raised issues relating to the scope and effect of the decision in the Islamic Academy case. It is prayed that by way of an interim measure, the same procedure should be followed as was followed in the immediately preceding year. It is stated that this year 9,000 students belonging to the minority community of Muslims had sat in the common entrance examination which has been held by the state government. Of the 9,000 candidates, 5,450 were successful, but it was found on further scrutiny that 1,000 eligible candidates were ineligible as they had not passed the higher secondary examination. This meant that only 4,450 students of this minority would gain admission into colleges on passing of the CET. It is submitted that in the previous year, the applicant, which was then only an unregistered association, had held a common entrance test called MEMCET. The state government, however, refused to recognize MEMCET examination last year. Nevertheless, after admitting the candidates who had opted for the minority institutions on the basis of their results in CET examination, several seats remained unfilled. In fact, after the successful CET candidates had been admitted against the minority quota, the institutions admitted the persons on the basis of MEMCET examination against the management quota. The state government then permitted all colleges to admit students only on the basis of the higher secondary result without any entrance test at all. Despite all this, only 10% out of the 30% of the government quota was filled, leaving 20% vacant seats in the minority institutions, causing a loss to the institutions. As at present, the quota has been fixed at 70% for the minority institutions and 30% for open admissions. Out of the 70%, 55% has been allocated to the management, that is 55% of minority students, 15% for management quota and 30% for the state government quota. The association is yet to hold its examination. However, having regard to the facts of the case, we permit the admission of CET successful minority candidates against the 55% quota if they so choose. The state government will be permitted to fill the 30% quota also out of CET candidates who need not necessarily belong to the minority community on the basis of merit and according to the choice of the candidate. In respect of 15% management quota and the balance seats, if remaining after making an adjustment of the successful candidates as particularized above, it will be open to the institutions concerned to admit them on the basis of the entrance test or MEMCET, which may be held by them for this year. It is being made clear that by this order we do not intend to decide as to whether the petitioner association is entitled to ask for separate examination or whether the petitioner is an association, whether Islamic education case has limited rights of the minority to associations alone, nor do we decide the appropriateness of MEMCET examination. It is made clear that this order is restricted to the members of the petitioner colleges. It is made clear that by way of these orders that we have passed today, we do not intend in any fashion to relax the schedule which has been fixed by the Medical Council of India in accordance with the Madhu Singh case. Let these matters be placed before the Honorable Chief Justice for appropriate directions for constituting a larger bench.